All right. So the second thing that we're going to cover under the judicial branch is court structure and appeals process. So we'll go from here. So the first thing that we'll discuss is that in the United States court system, it operates with a dual court system, meaning that we have two levels. So we have the federal courts, okay, which means you have a Supreme Court and inferior courts, but you also have a system of state courts. Because keep in mind, we operate under a system of federalism, which means there is a split between a federal level of government and a state level of government. So it makes sense that we would have two court systems. So with the state courts, you have trial courts, appellate courts, etc. So appellate courts is just another word for appeal. So what happens is if you are convicted in a trial court, you can move to an appellate court to appeal the decision, which means that you want the case to be revisited in case they would overturn it and you would be found not guilty. Each handles issues and grievances at their level. And again, we said this is a model of federalism. Okay, so for jurisdiction, jurisdiction is just a word that basically explains the specific authority or who has the authority to basically rule or hear a case or convict of a crime, things like that. So again, you've heard of police jurisdiction, which means they have a specific jurisdiction or authority to arrest you or patrol certain areas. You also have, like we were talking about here, court jurisdiction. So technically, which level of the courts we're able to hear or rule on a case. So this says jurisdiction determines whether a case is heard on a state court level or a federal court level, and which one specifically. So for example, if you commit a crime in the city of Tuscaloosa, let's say it's something small like robbery, okay, you would go to your local trial court, which would be the courthouse in downtown Tuscaloosa, okay. So exclusive jurisdiction means that one court has the sole authority to hear a case. In this situation, they would have exclusive jurisdiction because the crime was committed in Tuscaloosa. Concurrent jurisdiction, this means that it's overlapping. A case may be heard in more than one type of court, state or federal. And this says the plaintiff can choose which court may be more beneficial. So jurisdiction, again, we've got original jurisdiction, which is the authority to hear a case for the first time. Appellate jurisdiction, the authority to review the initial decisions of a lower court. I told you that the root word of appellate is to appeal. So again, when you appeal something, it means that the courts are going to review the original case and determine whether or not the original decision was made in error, and then they would probably potentially overturn it. You've also got trial courts, whether state trial courts or U.S. district courts have original jurisdiction. So like we said, an example of a trial court would be something like your local courthouse, okay? And that's where they would just hold trials. You even have state trial courts, so we would get to that later. Courts of appeals at either level or federal levels have appellate jurisdiction. So, for example, the state Supreme Court in Montgomery, they also have the power to appeal or overturn cases. And the same thing with the Supreme Court. They are the highest level of appellate jurisdiction because they are able to rule on cases or also appeal cases. So there's three types of state courts that you need to know about. The first one is a trial court, which is known as Superior Court. It is for civil or criminal trials that may be held before a single judge or jury. One thing that you need to know is that depending on the type of crime or depending on the type of trial, it may not always warrant a jury. So sometimes you might just go in front of a judge and then later he would rule whether or not you would have a full jury trial. Intermediate or appellate courts, they stand between the trial courts and the state Supreme Court. So again, these are courts where you can appeal a case decision for it to potentially be overturned. And you also have a state Supreme Court. This is the highest court in the state judicial system. So, for example, we said the Alabama Supreme Court in Montgomery. This would be our highest court in the state of Alabama. Federal courts. The Supreme Court, we said this is the highest court in the United States. This is also the only court that was originally mentioned in the Constitution under the judicial branch, but it did leave room for other courts to be created. So you also have inferior courts, which are the lower federal courts. You've got district courts. There's 94 total. They are trial courts that are the first to hear most federal cases. And I know you hear the word trial courts and you're thinking, well, I thought that was just a state thing. No, all federal cases or all, federal decisions. Think about these have to do with things like the Constitution. They have to do with laws. They have to do with, let's say, some sort of conviction that it was actually across several states. Those are the kind of cases that these federal courts will actually hear. You've also got the U.S. Court of Appeals. And so if you have any kind of decisions that are made in those lower courts, once you decide you want to appeal that decision, you would move up. There are 13 of these. Appellate courts that hear cases have previously been ruled upon. They look for errors in case decisions. So just to show you a quick, just to show you a quick example of what I'm talking about, and I will include this in the section for you to look at. This is just a graphic organizer of the appeals process. So again, we've got on one side, we've got the state trial courts. Then if you move up to intermediate appellate courts, okay? So if, let's say, you're convicted from something simple, and you want to appeal your case, okay? Let's say that they, don't appeal your case. You could move up to the state Supreme Court, and then eventually it could go to the Supreme Court in the federal level if it is of a constitutional matter, a legal matter according to the law, or some sort of multiple state issue. Okay, so those are really the main things the Supreme Court handles. On the federal level, you've got your district courts, then you've also got your U.S. Court of Appeals. So we go back to this. Okay. All right, so this is a map, and it just shows how these judicial circuits are broken up. And that was the appeals. So we'll move on to this. Constitutional courts versus legislative or special courts. So we said that the constitutional courts, those established by Article 3 of the Constitution. Now, I know that there are 3 listed here, but you will have a test question that's kind of tricky. Technically, the Supreme Court is the only one mentioned. However, the Constitution established the fact that the legislature could create more courts, and also that the federal government could also create more courts. So the Supreme Court was the only one that was technically mentioned in the Constitution. All right, and then on legislative courts, these are courts established by Congress for special purposes. So, for example, you have your U.S. Tax Court. You can imagine what that has to do with. It's taxes. You also have your U.S. Court of International Trade, and you have the U.S. Court of Appeals for the Armed Forces. So if you're in the military and you commit some sort of crime, or there's any kind of issue that comes up, you don't go to a regular court. You would go to the Court of Appeals for the Armed Forces. Now, the appeals process. So let's say, again, like you're convicted of a crime and, or some sort of case, and you feel like you've been wrongly convicted and you want it to be appealed. Okay, so typically those cases start in the lower courts, either state or federal. If one state believes there's been an error in judgment, they can appeal the case to a higher court, the appellate court. Now, again, just so you know, criminal cases do not go to the Supreme Court. So for my example, I could also mention, let's say, again, we'll talk about, we'll just say Brown versus Board of Education, okay? So originally, Brown versus Board of Education, it started out on a lower level in the state courts. They found that it was legal for segregation, so they appealed that case. The appellate court also found that it was legal, and they did not overturn the decision. But then again, the Supreme Court finally heard Brown versus Board of Education, and they actually overturned the previous rulings, and they said that segregation was actually illegal according to the Constitution, which gave us desegregation in the education system. So that's just an example of the appeals process. Again, like I was saying, if you're convicted of some, random crime, you're not going to go to the Supreme Court because it won't reach there. The Supreme Court only hears cases, like I said, that have to do with the Constitution or have to do with congressional laws or executive orders, or they handle state disputes, and that's it. So it's just, we'll explain this later. All right, so again, this is the graphic organizer for the appeals process to the Supreme Court. I will also include this as an attachment in this section for you to refer back to, because you have an activity that you're going to complete with this. And we'll stop here.